The first time we met was on Zoom. It's actually really funny. Blake, so I was zooming in with Blake and Justin, and they were in the same room. And Blake was like eating some lunch, and we were having a full blown conversation. And I was asking Blake questions, and she was telling me like stories and anecdotes, and being very enthusiastic. And I was like, man, she's just not listening to anything I'm saying. She's not acknowledging anything I'm saying. And so she thought I was frozen, and I thought she was ignoring me. It turned out I was on mute the whole time.
Hi, friends. It's Katie from Without a Crystal Ball. Welcome back to my channel. Yesterday, Brian Friedman and Blake Lively's attorneys were on record with Deadline, with Page Six, with Us Weekly, all talking about this subpoena and what it means. And I brought up in the end of my video what they said, but today I want to talk about what did Brian Friedman mean with his statement? What did he mean? And what could this mean for Blake Lively? Because it's not looking good. So, to help you understand and give you a rundown, Brian Friedman and Justin Baldoni are saying that on paper, there was this case that was titled Van Zandt Inc. versus Doe Defendants. But in reality, it wasn't about justice, it was about access. The company that is owned by Blake Lively and Ryan Reynolds, who are high powered, high profile, and well lawyered, they filed it, didn't name a real defendant. There was no clear target, no active legal dispute, and a vague claim. And buried inside of that, there was the subpoena, a subpoena that, according to the Daily Mail, was not signed by a judge. The case was never assigned to a judge or to a clerk. And the mystery around the subpoena remains because Blake Lively has not even provided a copy to Baldoni. Now, we know that the subpoena and this lawsuit could have seemingly been filed because in August, Stephanie Jones had obtained the phone and the records of her employee, Jennifer Abel, who quit and offered her letter of resignation in July, but Jones subsequently fired on August 21st. And on August 21st, the same day that Abel turned her phone over to Jones, Jones then provided information to one of the Lively parties because, according to court records, Leslie Sloan contacted Melissa Nathan and said, I saw the text messages, you're going to be sued. The problem, Stephanie Jones had a non-disclosure agreement and was not allowed to disclose the confidential information about Wayfair to third parties unless she had a court-ordered subpoena or was ordered by a court to hand it over. And she had a confidentiality agreement that she would not violate the information provided about a client to third parties. In order to cure this improper disclosure, the belief is they filed this sham lawsuit in order to cure the defect of the improper disclosure and help Stephanie avoid a possible breach of contract lawsuit by Baldoni, Wayfair, and Abel. The problem with the subpoena was there was no defendants. Baldoni and Abel were not notified. They had no idea that their information was being targeted. No notice, no chance to intervene, no opportunity to object. His name was never on the caption, but he was the subject. Jen Abel's phone was the target, but the phone was not listed in the lawsuit. But the subpoena stated they were looking specifically for that phone. The subpoena also wanted records from December 1st, 2022 to present. The same timeline was used when Blake Lively attempted to issue subpoenas in her federal case and the judge quashed the subpoena. That quash by Judge Lehman is looking a little bit worse for Blake Lively because Blake seemingly was attempting to gain evidence that she brought into the complaint via that subpoena from Van Zandt Inc. And the judge in this case would not allow her to do the same thing, meaning she does not have access from this court to obtain those records. His team said this was done in bad faith and constitutes a flagrant abuse of process. And they are so right to call this out because what this represents is more than just a legal trick. It's a breakdown in how the system is supposed to work. Subpoenas are powerful tools, but they come with rules, and you're supposed to tell the person being targeted. You're supposed to give them a chance to defend their rights. But when a company with a celebrity backing files a lawsuit with no real adversary and uses it to collect sensitive information about someone uninvolved, that's not legal strategy. That's a procedural ambush. It's a reminder that in the wrong hands, the court system can be twisted, not to protect rights, but to quietly strip them away. This was used to spy, surveil, not to legally obtain records. And if you obtain information by stripping rights from someone else, you can get into trouble with court. So, Justin's team has made a lot of big statements recently, but a statement they made yesterday is at issue right now, and what I want to talk about because what they signaled yesterday indicates there are new filings to be coming on the horizons, and it's not exactly what you think is coming. Brian Friedman's new statement that he issued yesterday indicates that there's more than just possible claims that could be filed against Blake Lively. Here's what he said. He said Miss Lively and Mr. Reynolds' company, Van Zandt, had nothing to do with this case, and they knew it. This sham lawsuit was designed to obtain subpoena power without oversight or scrutiny. And in doing so, they denied my clients the ability to contest the propriety, nature, and scope of the subpoena. There is nothing normal about this. Officers of the court have a duty of candor to the court and an obligation not to file fictitious lawsuits that have no basis in fact or law. This was done in bad faith and constitutes a flagrant abuse of process. That's a lot, loaded words. And for those of us that are not legalese, we might not know what he means. In this case, there's a few reasons why this is bad faith. First of all of the cease and desists that were sent from Blake Lively and Ryan Reynolds to Justin Baldoni and Wayfair, none of them mentioned Van Zandt Inc. as an interested party in the case. They named other businesses connected to Blake and Ryan, like Mint Mobile. Why would Mint Mobile care, right? Mint Mobile, Betty Buzz, Betty Booze, Blake Brown, Aviation Gin, Maximum Effort, those companies. But Van Zandt Inc. was left off the list in all of the cease and desist. Also, the attorney that filed this quote unquote sham lawsuit, Samantha Katze, she's not listed as any of the attorneys of the millions that have filed to be Blake and Ryan's attorneys in this case. In fact, even today, Blake had two new attorneys from her Texas case, both Laura Prather and a guy named Michael Lambert. They both work out of Austin. It's part of her Austin case against Wallace. Both of them are now seeking to be a part of this case in New York. I don't know why. We'll have to wait and see. But Blake has tons of lawyers listed in this case. Not one of them is Samantha Katze. So you have a couple of things here. Samantha Katze, not a part of this case, but Samantha Katze was the one that put out the subpoena in the Van Zandt case. Van Zandt not named in any of the cease and desists. And Van Zandt not named in this current complaint. So many problems. But what does this mean? What could he possibly do? Well, there's many. The possibility of if all of these allegations hold true, if everything that we think happened, they could actually face serious consequences, both in terms of sanctions and potential civil liability. Here's some possible consequences. So sanctions and or dismissal. So bad faith litigation could lead to sanctions under Rule 11 of the Federal Rules of Civil Procedure. They can dismiss the case, impose fines, or award attorney's fees to Baldoni for having to deal with a baseless lawsuit. They can also exclude the evidence obtained from the subpoena or worse, dismiss the lawsuit entirely, calling it a frivolous filing designed to circumvent the rules. Now, the judge could throw it out as a part of the process, but they can't file a motion to dismiss because they've already filed an answer to the claim. But they can file a motion for a summary judgment, and we'll get there in a second. Another thing is that she could face a claim for abuse of process, and that's a tort claim that arises when someone misuses the legal system for an ulterior motive. If they can prove the lawsuit was merely a cover to gather information about him, they can pursue damages for this malicious use of process. Did you hear that? Malicious. There's also spoliation and privacy violations. If it's proven that her team knowingly violated discovery rules or privacy rights to get information about Baldoni, it could trigger spoliation claims, especially if the documents or communications were destroyed or manipulated. And we know in this case, they've been talking about cherry picked information, right? And we already know that Judge Lehman, when he shot down and quashed the subpoena, stated that her request for all of those records, the phone records, documents, text, all of it from December 1st, 2022 to present, he called it an invasion of privacy, too broad. And she did the same request in the case for Jen Abel's phone. She wanted all the records from that phone from December 1st, 2022 to present. Blake could also potentially face new lawsuits, and the types of lawsuits she could face are tort of abuse of process. He could bring a civil suit alleging that she abused the legal process and she did it to conduct an improper investigation into him without allowing him a chance to defend himself. He can also sue for defamation or privacy claims. So if any of that information was used to damage him and it was revealed through this process, or if the subpoena information was used inappropriately to harm his reputation, he could explore defamation or invasion of privacy claims, which he's currently suing for. Ethical violations also can be here. So she could face disciplinary action for filing a lawsuit without legitimate purpose. Her attorneys could, and they might also be reported to a state bar or faced with professional sanctions. Now, as far as the motions, what are the motions that could be filed and what are the documents that could be filed as it relates to the evidence? This evidence is possibly obtained through questionable means. So the first motion he could file, or one of the first, is a motion to strike evidence, to strike the subpoena evidence from the record. That's one of the most straightforward ways to challenge the improperly obtained documents. Since he was never notified about the subpoena, and since the Van Zandt lawsuit was never intended to be about him, the evidence gathered through this route could be deemed illegally obtained. If his team can convince the court that the subpoena was a bad faith effort, the judge could exclude the evidence obtained from it. Without the evidence, the case against Baldoni could lose much of its foundation, severely undermining her position. Another motion they could file is a motion for a summary judgment. The legal team could file a motion for a summary judgment. It's a powerful legal move, but they could ask the court to rule in Baldoni's favor because there's no real evidence to support the claims being made against him. Baldoni's attorneys would argue that without the subpoenaed evidence, there's no legitimate case left to pursue. And this is a huge point because much of the claims in this case, although she brings up the sexual harassment, what she seems the most upset about is the smear campaign. And without the smear campaign, she really can't sue for the sexual harassment because all of that was taken care of. And by the way, she never really complained about it at the time or took the steps at the time. And there's a statute of limitations when it comes to the sexual harassment, and there's a statute of limitations with the federal courts when it comes to these types of claims as well. And without the smear campaign, all of the claims and the foundation of this entire case fall apart. So if the court were to grant that motion for a summary judgment, it could end the case right then and there. And she would face a huge defeat in the federal case. It would be devastating for her, and it would suggest that the entire case was built on tainted evidence. Another way that they can look at this and hammer at them is motion for sanctions. His team could file what's called a motion for sanctions, and this is where things get really tricky for her. A motion for sanctions could target the bad faith actions in issuing a subpoena and manipulating the legal process. If the court finds that Lively and Reynolds were abusing the legal system, they could face financial penalties, including having to pay his legal fees. A sanctions motion would send a clear message that trying to manipulate the system in such an underhanded way has consequences. Not only would she be risk paying a hefty fine, but her reputation could suffer if they ruled in his favor. One of the most serious implications on if this was done in bad faith with the attempt to invade someone's privacy and abuse the court system, under federal law, she could be charged and Ryan could be charged with obstruction of justice. I know it sounds far-fetched, but hear me out on this. So obstruction of justice could come into play if the subpoena was issued by Van Zandt Inc. and it was done, and if it was not done in good faith. So if they used it as a tool to gather information about Baldoni for an ulterior purpose, it could be seen as an effort to obstruct the legal process. So if the Van Zandt lawsuit, which had no defendants, so for instance, the Van Zandt lawsuit had no named defendants, it may have been a sham, a fake lawsuit designed solely to get subpoena power without any real legal dispute at its core, because the legal dispute that was named in that lawsuit was fictitious. The subpoena issued in that case targeted his communication, Baldoni's, Abel's, and Wayfair's, which were unrelated to the subject matter of the case, and he was never notified about it. If this was done intentionally in order to bypass the proper legal procedures and to gather information about Baldoni for a federal case without his notice, it could be construed as a deliberate attempt to manipulate the legal system. That action alone could be categorized as obstructing the course of justice because it impeded Baldoni's ability to contest the subpoena or protect his privacy rights. The intent behind issuing the subpoena, if found to be fraudulent, could be a key in determining whether or not the obstruction occurred. And then another aspect here is that there was a failure to notify Baldoni, Abel, and the Wayfair parties. So another way this could be charged and could come into play is through the failure to notify Baldoni about the subpoena. The failure to notify an individual when issuing a subpoena is a direct violation of procedural rules and could prevent the party from objecting to the subpoena. His rights were effectively denied because he had no opportunity to challenge the subpoena or argue that the documents requested were irrelevant or too broad. And if Lively and Reynolds knew this and still moved forward and obtained Baldoni's communications secretly, that could be seen as deliberately obstructing his ability to contest the subpoena and therefore obstructing justice in the case. And then another way is that if it's found that it was filed for no legitimate purpose, but rather as a backdoor tactic to obtain private information about Baldoni, this could be classified as obstruction of justice. The legal system exists to resolve disputes based on real issues. When a lawsuit is filed solely to gain leverage or access to information for use in another case, especially when there are no valid defendants or legitimate claims, this undermines the integrity of our judicial system. And if they used their company, Van Zandt, to initiate the lawsuit just for the sake of obtaining a subpoena power to access his private communications and Jen Abel's private communications about her and Ryan, it could be seen as corruptly influencing the course of justice and therefore obstructing it. I know it sounds wild that this could be a possibility, but he has said it was a backdoor tactic. He said that they were not given notice. He said they violated his rights. That's all signaling at a possible criminal investigation. If obstruction of justice is proven, there can be serious criminal consequences. And I'm not kidding how serious these are. It's a federal crime. It includes fines, imprisonment, or both, depending on the severity of the case. So if a court were to determine that Lively and Reynolds intentionally used the legal process to manipulate the system to gain access to his private communications, they can be charged with obstruction. Criminal obstruction charges can be added to the federal case against them if it's found that they intentionally interfered with his rights or used the system to gather evidence under false pretenses. So, federal court is all about violating others' rights, violating constitutionally protected rights, not giving him notice and doing it this way by concealing it from him, knowing that it was his communications they were after. It's a big problem here. And even if they aren't pursued, like even if criminal charges weren't pursued, say the prosecutor's like, I don't want to deal with this, they can still seek sanctions against them for abusing the legal system. So they could be financial penalties for improper use of the legal system, reimbursement of his legal fees, discipline actions against Lively and Reynolds, attorneys, which can include disbarment and sanctions for lawyers, exclusion of evidence, like we've talked about, and all of this could have a devastating effect on them. How they prove this, and if they were going to pursue criminal charges, they would have to prove they used a fraudulent legal process to gain access to his communications in a way that was not lawful or permissible. They have to prove that the subpoena was part of a scheme to undermine his ability to contest the subpoena or to access documents that were irrelevant to the case at hand. I think it's pretty clear that Baldoni's communications were not about Van Zandt's case. They would also have to prove that the failure to notify Baldoni or give him a chance to challenge the subpoena violated procedural safeguards meant to protect individuals from unfair legal tactics. The intent behind the action also has to be determined, and that would be to obstruct his legal rights, therefore undermining fairness in the legal proceedings. So, if this is all determined that they did this deliberately and in bad faith to gather information illegally or to manipulate the legal system, it can result in serious consequences, including criminal charges for obstructions of justice. The charges would seriously depend on how serious the misconduct was, how significant the abusive process was, and what the ulterior motives were. But it's not just about fighting for Baldoni, it's about holding people accountable, like Lively and Reynolds, who believe they are above the law and that they can use tools to surveil and spy on others. Throw out all of the arguments about sexual harassment, throw out those claims, throw it all out. Even if he did all of that, and I don't believe he did, no one has the right to invade someone else's privacy through the illegal use of a subpoena to gain access to private communications. No one has a right, no matter how wealthy they are, to violate constitutional protected rights of any citizen in the United States. Thus far, we have not seen any evidence that Baldoni, Wayfair, or anyone have committed any crimes. But we are now seeing evidence that Blake and Ryan may have had such a vendetta to get revenge against Baldoni. They were willing to obstruct justice to do so. They were willing to commit a federal crime. Now, all of this would have to be proven, but I want people to realize it's a possibility. And I think that's why some people think maybe Stephanie Jones has hired a criminal defense attorney. Thus far, all of the attorneys that are involved are mostly civil attorneys. Thus far, if criminal attorneys are involved, they would be more involved behind the scenes. And if a criminal investigation were happening, none of us would know about it. The FBI does not announce their investigations. Okay. The FBI does not say, okay, we are going to start investigating Blake and Ryan, because that would like tip them off, and it can lead to spoliation of evidence. People will destroy evidence. It can contribute to witness tampering. And so they do things under the radar. But I think some of Friedman's public statements are indicating there's probably discussions right now about that possibility, because that's how serious this is. And so when her team keeps saying this is normal, this is typical, we didn't do anything wrong, you have to think of what that lawsuit said. The lawsuit stated she didn't know who the people were. She didn't know who the defendants were. The lawsuit didn't even identify the information that had been revealed about her that damaged her reputation. And the lawsuit did not reference Justin Baldoni. Justin Baldoni has no relationship to Van Zandt Inc. That's what matters. I briefly touched on what the criminal penalties would be for obstruction of justice. What what could they be looking at if this went this far? Imprisonment is the first. It's a felony under the US law, and many and oftentimes convictions can result in prison sentences, and they vary in length depending on the nature of the obstruction and which law was violated. The standard penalty, which is under 18 US Code 1503, which covers obstruction of justice, they can be sentenced to up to 10 years in federal prison if convicted. And then for some offenses that involve it, it could mean like they destroyed evidence or they tampered with witnesses. Penalties could be reduced or increased. And it just all depends on the severity of the act. They can also be facing fines and financial penalties. They can be facing fines of several thousands of dollars to millions of dollars, depending on the kind of harm they caused. They could get probation instead of imprisonment. They could be sentenced to probation, which is the less severe form, but it could still involve strict supervision. It could be for months or years. And then the other is restitution. And that's if obstruction resulted in financial harm, for example, interfering with a business investigation or preventing resolution of a legal matter, it can be the court may order they pay restitution to the affected parties. So I am not a lawyer. I am simply here to share with you what are options, what could be happening, what are the thoughts running through Baldoni's side, possibly. What is Brian Friedman thinking about all of this? And I'll just end by saying this. I don't know if it'll go criminal, but what I do know is that I've covered a lot of cases in the years that I've worked as an investigative journalist. I've uncovered horrible actions by very well known and wealthy people. I have learned that greed, wealth, and power are often a catalyst for corruption, evil, and crime. And when someone has unchecked power and unlimited resources, many times they will believe they are above the law. And there's been times in my work where I have felt disillusioned or I've felt discouraged. There was a case I covered for years, and it took more than 4 years from the time an indictment happened to the time a criminal conviction came. And during those 4 years, I was terrorized by the individual under indictment because I called it from day one, because I knew what was happening and I knew this person that had a very public platform was manipulating the public, misleading people, defrauding people, and dangerous. And the day that that person was convicted, I breathed a sigh of relief because I knew that when they were in jail, they could no longer terrorize me. This is how I imagine Justin Baldoni and Wayfair feel up against malignant narcissists that will stop at nothing to destroy their targets. And it takes very little to piss someone off that's a malignant narcissist. We might never know what the agenda is here or why they went this far, but they did. And to this day, their attorneys have the media gaslit into believing that the steps they took were legal, just, and normal. Don't forget that no one I know in the world has ever filed a lawsuit like Blake and Ryan. I've met not one person who has ever gone to such lengths to invade someone's privacy. And don't forget that this case is not just about Justin. This isn't about sexual harassment. This case is destroying women too. Women, Jen Abel, Melissa Nathan, Emily Baldoni, Natasha Heath, and all of the staff that are females at Wayfair, and all of the agents and partners and managers that we don't know about that are women. All of these people, not just Justin, not just Jamie, but women are being destroyed as well. And Jed Wallace too. A heart attack. A heart attack came out of this. Justin in the hospital for a spinal infection. And meanwhile, Blake is off gallivanting in Europe, promoting a new film, becoming Time's most influential person because she donated money 7 years ago because she had her wedding on a plantation and she needed to get out of public backlash. And all this, all while she and Ryan are seemingly pretending like nothing's happened and they want us to believe they're victims, they're not acting like it. And meanwhile, Justin and his whole team and his family and his friends and his extended family, they're all becoming pariahs and not welcome in society because two people with a huge platform and a lot of money and influence were set on destroying him and his friends and family and everyone that supports him and his studio because they stood up for themselves. Justin's case is not just about Justin. It's about a victim who's being victimized, and men can be victims, and a victim having the right to say, I'm not going to do that. I will not be bullied. And I hope that in some point in time, our mainstream media wakes up to the idea that men and women can both be perpetrators, that women can lie as easily as men, and that men can be victims of false accusations. And in Hollywood, those accusations are weaponized so frequently. In this case, I just want justice for Justin and for Wayfair and for his family and for his friends and for all of the people involved that have been affected. Jen Abel, Melissa Nathan, Jed Wallace, the like, Jamie Heath, Steve Sarowitz. But we'll keep fighting for them. We'll keep digging. We'll keep searching. And as always, thank you so much for being here. I want to say thank you to Candace Owens for the shout out in your podcast the other day, for your shout out on Instagram. We don't share very many of the same political beliefs. We really don't share a lot of the same beliefs about a lot of things, but on this we agree. And sometimes that's all that matters. One topic can unite people that are different. So tell me what your thoughts are in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.